Good morning. This is Satyabama. We have with us here Srimati L. Jayanti, Assistant Director. Good morning, Madam.
Good morning.
Can you throw some light on the appeal provisions under the CGST Act 2017, please?
Yes, of course. Appeals provisions are governed under Chapter 18 of the CGST Act 2017. The appeal mechanism works like this. The first level of appellate authority is depending on the order in original passed and the adjudicating authority who is passing the order. So, the first level of appellate authority for orders passed by superintendents, assistant commissioners and deputy commissioners of the department will be joint commissioner appeals or additional commissioner appeals. And for the orders passed by joint commissioner appeals or additional commissioner appeals of the department will be the commissioner appeals.
Is there any time limit for filing appeal?
Of course, for the taxpayer, it is within 3 months from the date of communication of the order, and for the department, it is 6 months from the date of communication of the order. And in both the cases, continuation of delay is available for a maximum period of 1 month, provided sufficient cause is shown for the delay.
What are the preconditions for filing appeal before the first appellate authority?
Appellant has to pay a pre-deposit, which will be 100% of admitted tax liability, 10% of disputed tax, which is capped at 20 crores, the maximum. If only penalty is disputed, then 10% of penalty. When the pre-deposit is paid, appellant gets immunity from recovery action, as the payment of pre-deposit provides for automatic stay on recovery of balance amount till the disposal of appeal.
Can you take us step by step through the appeal procedure?
Yes, I will do. First step being filing of appeal. Appeal form GST APL 01 is the form in which the taxpayer is supposed to file an appeal, and for the departmental application it is GST APL 03. This is filed electronically on the GST portal with grounds of appeal, statement of facts and proof of pre-deposit. A provisional acknowledgement is generated instantly. The second step will be scrutiny and admission. The appellate authority verifies limitation period, pre-deposit compliance and documentations. Defects, if any, must be rectified, and after acceptance, a final acknowledgement is issued in form GST APL 02 and the appeal is admitted. And step 3 will be notice to respondent. Copy of appeal is forwarded to the adjudicating authority in case of party appeal and to the party in case of department appeal. Relevant records are called for examination wherever necessary. Additional grounds of appeal can be admitted if the appellate authority is satisfied that the omission was not willful or unreasonable. A hearing date is then communicated. The appellant or authorized representative presents arguments and may file written submissions. Maximum 3 adjournments are allowed. The authority may call for additional documents as evidence and conduct further inquiry if required. Then the appellate authority may confirm, modify or annul the order but cannot remand the case. Under subsection 75(2), the appellate authority can direct the adjudicating authority to redetermine the tax if the demand was found to be not sustainable under section 74 but has to be determined under section 73, and time limit for redetermination is 2 years from the date of communication of the direction of the appellate authority. If enhancement of penalty or reduction of refund or ITC is proposed, a show cause notice and an opportunity of hearing are mandatory. Where the appellate authority is of the opinion that any tax has not been paid or short paid or erroneously refunded, or where input tax credit has been wrongly availed or utilized, no order requiring the appellate to pay such tax or input tax credit shall be passed unless the appellant is given notice to show cause against the proposed order and the order is passed within the time limit specified under section 73 or section 74 or section 74A. After all these processes, order is issued in writing stating points for determination, decision and reasons. The order passed is to be communicated to the appellant, respondent and the adjudicating authority. Copies have to be sent to the jurisdictional commissioner and the jurisdiction commissioner of state or union territory. The summary of such appeal and the decision is uploaded in APL 04, and for this process the target disposal period is 1 year from the date of filing appeal.
Can a person who has filed appeal withdraw it at any time?
Yes, there is withdrawal provisions in CGST Act. The appellant may at any time before issuance of show cause notice under subsection 11 of section 107 or before issuance of the order under the said section, whichever is earlier, in respect of any appeal filed in form GST Appeal 1 or GST Appeal 03, file an application for withdrawal of the said appeal by filing an application in form GST APL 01 or 3W, provided that where the final acknowledgement in form GST APL 02 has been issued, the withdrawal of the said appeal would be subject to the approval of the appellate authority, and such application for withdrawal of the appeal shall be decided by the appellate authority within 7 days of filing of such application. Provided further that on any fresh appeal filed by the appellant pursuant to such withdrawal shall be filed within the time limit specified in subsection 1 or section 2 of 107 as the case may be.
Are there any decisions or orders against which appeal cannot be filed?
Yes, of course, there are certain cases where appeal cannot be filed, and section 121 of the CGST Act provides certain situations where appeal cannot lie against any decision taken or order passed by an officer of central tax if such decision taken or order passed relates to any one or more of the following matters, that is, an order of the commissioner or authority empowered to direct transfer of proceedings from one officer to another officer, or an order pertaining to the seizure or retention of books of accounts, register and other documents, an order sanctioning prosecution under this Act, or an order passed under subsection 80, that is, payment of arrears in installments.
What is the purpose of revision and who is a revisional authority?
Yes, let me tell you. The revisional authority is a senior GST officer. It is usually the principal commissioner or commissioner for the orders issued by the jurisdictional joint commissioner or additional commissioner of CGST. And in the case of orders issued by superintendents, assistant commissioner or deputy commissioner, it is the joint commissioner or ADC of the GST department. They have the power to re-examine the legality and correctness of decisions or orders passed by their subordinate officers. Revision is used to correct legal errors, correct improper or irregular decisions, protect government revenue, ensure uniformity in tax administration. It acts as a supervisory remedy when no appeal has been filed and the order is found to be improper or prejudicial to revenue.
How does the revisional authority function?
The revisional authority will call for and examine records. He will review any proceedings of his subordinate officers. He will check for the legality and propriety of the orders issued by the jurisdictional officers, verify if the order is legally valid, properly reasoned, and has been passed following due process. And after giving the taxpayer an opportunity of hearing, the authority may enhance the tax liability, modify the decision or annul the decision, or even set aside the order and direct fresh adjudication. And the time limit given for such revision is within 3 years from the date of the original decision or order.
Is there any situation where revision cannot be done?
Yes, revision is not allowed if the order is already under appeal or the time limit for appeal has not expired. The matter has already been decided by any appellate authority. In such cases also revision cannot be done. And if the order has been passed and 3 years have elapsed after passing the order, no revision can be done.
What is the relief available when a person is aggrieved by the order in appeal or a revision order?
The next appellate forum is the GSTAT, that is the GST Appellate Tribunal. which is the next forum available for persons who are aggrieved by orders in appeal or revision orders. An appeal can be filed before the tribunal in form GST APL 05 within 3 months from communication of appellate authority's order or the revisional order, after payment of pre-deposit of full admitted dues and additional 10% of the disputed tax over and above the earlier deposit, which is subject to a maximum of 20 crores. In cases only where penalty is disputed, 10% of such penalty has to be paid. Here also, the appellant gets immunity over recovery when he pays pre-deposit. That is, when the pre-deposit is paid, action for recovery of dues is stayed till the disposal of such appeal. In case of department, where the department finds an order issued by the first appellate authority is not proper, may file an appeal before the tribunal within 6 months of issue of such order. Here also, condonation is available for a period of maximum 3 months, and here also sufficient cause has to be shown for such delay by the appellant. The time limit for filing cross objection is also available here, which is 45 days of receipt of notice. And here, filing of cross objection, if delayed, another 45 days is available again if sufficient cause is shown for the delay.
What is the fee for filing appeal before GSTAT?
The fee for filing appeal or restoration of appeal shall be 1000 rupees for every 1 lakh rupees of tax or input tax credit involved, or the difference in tax or input tax credit involved, or the amount of fine, fee or penalty determined in the order appealed against, subject to a maximum of 25,000 rupees. Here, a minimum payment of 5,000 rupees should be made regardless of the tax liability, provided that the fees for filing of an appeal in respect of an order not involving any demand of tax, interest, fine, fee or penalty shall be 5,000 rupees. And there shall be no fee for application made before the tribunal for rectification of mistakes.
Can you elaborate the procedure for appeal?
Yes, the first step being filing. If one order in appeal is passed with reference to more than one order in original, then the number of appeal shall be as many as the number of order in originals. An appeal will be filed with the statement of facts, grounds and certified copy of order. Registry scrutinizes filing, registers upon defect rectification. Then notice is issued to the respondent. Reply and cross objections may be filed by the respondent. The tribunal then fixes date of hearing. Parties present oral and written arguments. Paper books and case laws are submitted. Additional evidence may be allowed. The tribunal may summon persons, call for documents, receive expert evidence and grant adjournments. After due processing as told now, then tribunal may confirm, modify, annul or remand the case for fresh adjudication with directions. Order will be pronounced in open court and signed by members. Copies should be sent to the appellants, respondents and also to the jurisdictional authorities. Summary of the decision will be uploaded in APL 07 in the portal.
If the order is defective, say it contains some mistakes, can it be rectified?
Yes, there are provisions for rectification of mistakes under section 161 of the CGST Act. Rectification application may be filed to correct errors apparent on record. Tribunal may also rectify it suo motu, or it can be done on being applied for by the person who is aggrieved. And these mistakes should be of purely clerical or arithmetic nature, and such mistakes only can be corrected. There is a time limit, of course, for correction for rectification of mistakes, which is within 3 months from the date of decision or order or notice. And no rectification shall be done after 6 months from the date of issue of decision or order or notice.
Thank you, madam, for throwing light on the first and second stage of appeals. I am sure the viewers will be benefited by this.
Thank you, Satyabama, for the patient listening.